Good afternoon, everyone. I was just giving a couple minutes for any last minute joiners to join us. So I am going to go ahead and start our presentation. I appreciate those of you that joined us on time. I do want to respect everybody's time on here, and so that we have the most and valuable use of the time of the presentation. This is a live presentation. If you have any questions throughout the presentation, please post them in the chat. And we will leave a few minutes at the end so that I can address any questions that you might have. So post them in there, and at the end, we'll do a recap so that as I go through the presentation, I kind of don't lose my train of thought of answering questions and going back and forth. So if everyone is ready now, it is 12:05. I think we're good. We're going to start this presentation, and we're going to kick it off. So thank you all for joining. Today, we're going to talk about a very important topic that I know oftentimes kind of is in the back burner. It's in the back of everyone's mind of, I need to get my estate planning done. I know it's something I have to do, but I never get around to doing it. Or a lot of people sometimes don't feel comfortable with talking about it because we are talking about death and what happens the day you pass away. So today we're going to get comfortable with the uncomfortable. And as I like to tell people, this is life. We need to talk about it and be prepared. And that way you have that peace of mind that you don't need any headaches or any interfamily fighting or anything like that when you're not here. That is what estate planning, one of the main goals is that it could do for you. So we're talking about don't leave your legacy to chance, the urgent estate planning steps that every family needs to take to protect you and your loved one. So for those of you who don't know me, my name is Alina Nuñez. I am an estate planning and probate attorney, and I also do real estate law. I have been an attorney for over 20 years, technically 20, I'm going on 22 years. And during that time, my profession, I started predominantly doing real estate and have transitioned into the estate planning and probate world in the last 10 plus years because it's very symbiotic. You have real estate and someone passes away. That's usually their biggest asset. So I found myself handling a lot of that. And from a personal journey, just to share a little bit, one of the things that got me into wanting to do the estate planning and the probate is dealing with my own parents and my father having had Alzheimer's and developed that and being able to help my parents plan for the future. So we had everything in place as we knew that this disease would progress, which it ultimately did. So this is very near and dear to my heart. I find it, there's nothing more that I love to do than to help people plan and avoid those headaches, because there's nothing more heartbreaking when clients come to me and they put this off, and they haven't done their estate planning, and it might be too late, or they find themselves having to go through a probate process that could have easily been avoided with some simple estate planning. So here are some tools. These are some common words you're going to hear me talk about during today's presentation, and you're probably maybe familiar with a couple of these. We are going to talk about wills and what is intestacy, what is a beneficiary designation, and what is a trust. So these are all tools that we use during estate planning to avoid probate, to properly plan, and to leave and protect our inheritance for future generations. So what to expect from today's presentation? As I mentioned, we're going to explore estate planning essentials, helping you make critical decisions for your family, your assets, any medical healthcare decisions that need to be made in the future, whatnot, and how to secure your legacy and protect that your wishes are fulfilled no matter of your family situation. That is the power that estate planning gives you, is to be able to say how you want your assets distributed or plan for your future, and you take that control versus leaving it in the hands of a judge, the court, fighting family, or anything else like in that situation. So for any of you that don't maybe are not 100% sure of what exactly estate planning is, like if you heard of it, you're like, okay, but I don't have an estate. There's often some misconception. People think, well, estates are wealthy people. I need to be rich. I need to have a lot of money in order to have an estate. And that's not true. Our estate assets that are considered part of your estate can be as simple as your car, any real estate that you own, the home that you live in, or the apartment that you live in, your checking and savings account, regardless of the value or the dollar amount that is in that account. Even furniture and personal properties are considered part of your estate. So your jewelry, artwork, anything to that effect are all part of your estate. Life insurance policies, annuities, and as I mentioned, artwork and jewelry. So all that makes up our estate. So when you sit there and kind of take a look at what makes up your estate, you would be surprised that you have a lot more valuable things that you would think of. And that is, some people, like I said, think that, oh, I have to be a millionaire. No, all of these things make up your estate and they all have a value. So the question I often get is, well, do I really need an estate plan? It's common. I'll get, well, I don't have a lot. My situation is very simple. I don't have a lot. So do I need an estate plan? Why do I need to bother having a estate plan? I'm not rich. I'm not wealthy. I'm not, Rockefeller, or, I'm not, Elon Musk. Doesn't matter. You need to have all of these affairs in place to make sure that your assets get distributed. So with a proper estate plan, you can ensure that the people you care about that you're leaving these assets to will be provided for or will be handled in a way so that they don't have to deal with going through a legal proceeding, going through court, through a probate process or anything like that. So when we talk about the key components or the main documents for estate planning, I always like to see that there's always 4 basic documents, and then from there we build on with additional documents. So here's a list of some of those basic documents. So the 4 that we always recommend that everyone should have, regardless of the size of your estate or whether or not you have children, you don't have children, anything like that, is your durable power of attorney, your healthcare designation, your living will, and your last will and testament. In addition to this, there are situations where a revocable living trust is a better option than a last will and testament. And I'm going to discuss the reasons why in depth further along in the presentation of the difference between the two, why one is better than the other, and how they're the same, but they're also very different. So first, let's talk about a durable power of attorney. So a durable power of attorney, or POA, is a document that you use during your lifetime to give someone the power or the responsibility to be able to make decisions and act on your behalf if you cannot make those decisions for yourself, meaning you have become incapacitated mentally or maybe even physically. So durable power of attorney is while you're alive. Once you pass away, the powers of that document cease to exist, and it's only to be used during your lifetime. So this is a situation where, let's say you have you do your power of attorney, and then in the future, heaven forbid, you develop dementia or Alzheimer's. If you already have that power of attorney in place, the person that you named to make those decisions on your behalf can take care of those affairs when you cannot, because you do not have the capacity, mental capacity to do so. This is probably one of the most important documents. All these are very important, but a lot of people I know focus on, well, what happens when I die? What happens when I die? What happens when I die? I always like to bring it back and go, we need to plan for that, but we also need to plan of what happens if you're alive and you can't take care of yourself, you can't make your own decisions. And that's where these documents become even more important than having a will and a trust. So with this power of attorney, a prime example, and I've had this with many clients of mine, they've come in, we've done their estate planning, they've done their power of attorneys, their healthcare surrogates and everything. And I get a call 5 years down the road from the son or the daughter that says, my mom has dementia now. She's developed dementia. We need to sell the house because we need to move her in with one of us. And we need the money from the house to be able to pay for her caretaker or place her into an ALF or into some other facility. She is alive. So if she did not have this power of attorney, you can't just sell that house. But because she had done her power of attorney, but now she no longer had the mental capacity to sign off on legal documents and make decisions, her children were able to sell that house. It's her money, put the money in her bank account or in a trust or whatnot, and be able to use that money during her lifetime to pay for her care, to have her in their home with them, but pay for a caretaker or have her placed into a facility and be able to pay for all her needs while she was alive. That is one of the most important benefits and one of the, I would say, the most common uses that we see with power of attorneys. If she had not signed that document and they did not have a power of attorney in place and she did not have the mental capacity, they would have to have opened up a guardianship case with the court, be involved in a legal process, have the court have three doctors examine her, determine that she does not have the mental capacity, appoint a guardian, and the court will always be involved in what happens with her money and her assets along with that guardian until the day she dies. And as I tell people, I am a lawyer, but the more you get the court or lawyers involved, the costlier you're going to deal with this transaction, with this process. It's going to be a costly process, where in having this proper estate planning avoids all of that. So that's one good example I like to give of the importance of having these documents. So the benefits of having the POA, as I mentioned, it's easy and economical. A durable power of attorney is much more affordable than having to do a guardianship case, and it prevents costly court proceedings to become incapacitated. And not only that, the cost, but it's empowering because you choose who you want to make your decisions for you without losing your rights to as far as your assets. Where if you don't have this, any family member, anyone can appoint and request to be appointed a guardian, and maybe it's not the person that you wanted to take care of you and look out for your well-being. So it gives you that empowerment as well as saving you on the cost of a guardianship. The second document is the designation of healthcare surrogate. This is, again, very similar to the power of attorney, but this is for everything medical related. This document, again, is used while you're alive. Once you pass away, the document is done. And it is, you're naming the person authorized to make medical decisions for you when you are unable to make your own decisions. So again, it's giving you that power to say who you want to make those decisions. It's giving you the ability to name that person and not have a last minute emergency present itself and you have two family members fighting in the hospital saying, well, I'm the daughter, I'm the son, well, I'm the oldest, I'm the one that's going to make decisions. But if you don't have a written document, the hospital's going to go, wait a second. If there's no written document telling us who has the authority, we need something from a court. And you will have to open up a guardianship, again, to be appointed the person's legal guardian to be able to make decisions. That's why it is so important to be able to have these documents in place. I tell my clients, hopefully you will never have to use these documents. Hopefully we will prepare them for you and it'll give you that peace of mind and you will never need to use them. But if you do, you have them in place. You have them based on your wishes and your desires of who you have peace of mind knowing that is going to make those decisions for you. And again, these documents are for when you cannot make your own decisions. So long as you have the capacity to and you make your decisions, that controls. This is only in a situation where you cannot. So who can act as a healthcare surrogate? Any competent adult who is at least 18 years of age. I always advise my clients as well to give me your primary person and to give me an alternate. You don't have to. You can only you could name just one person, but I always ask, give me two. You never know if an emergency presents itself and the person that you have named as your primary surrogate is out of the country, is on vacation, away somewhere. At least if you have a second person, that person can step in and make decisions until that primary person returns. So when you're getting ready to schedule a consultation, hopefully with us, to discuss your estate planning, these are all things I want you to think about. If you find yourself in that situation, or if you, heaven forbid, in the future, because again, this is what we're doing, we're preparing for worst case scenario, who would be the one to make those decisions? Who would you want? And it doesn't have to be the same person. Maybe you have someone that you trust to be more medical decisions, and someone you trust more with the power, with the durable power of attorney to make more like financial decisions. And that's okay. You can name, one for one and one for another. You can name two people. Let's say I've had clients that have children. They don't want to leave one child out or choose any preference, so they want the two of them to act together. You can do that. The issue with that is obviously now you're having two people that have to kind of be on the same page. I had a client recently that named all three together because they figured 2 out of 3 majority rules, they would be able to make a decision if there was some sort of argument. Where with two people, you might have a tie and it'll be hard to kind of, but you can name two people together. I always suggest that you name a primary and a secondary, but it is possible. So a living will, this is very different than a last will and testament. Okay. A lot of people confuse this. They'll call me, oh, I need my living will done. I'm like, I think you mean your last will and testament. A living will is different. What a living will is, it's a legal document that spells out your medical treatments that you would or would not want to be used to keep you alive. Okay, so this is not like a DNR. It's not a do not resuscitate. This is a document that states that if you are in a persistent vegetative condition, an end condition where two doctors have determined that there is no medical probability of you recovering from such a condition, then you're letting your desires be known of whether you want to be maintained alive until absolutely everything has been exhausted beyond belief, or if you say, once that decision has been made, let me die naturally and don't prolong the process of dying artificially if there's no purpose for it, if there's no ability for me to recover from such condition. If it's just to maintain me in a hospital bed as a vegetable, I do not want to be maintained that way. Let me die with dignity, and these are my wishes. So you are making that decision. You're not leaving that decision up to your healthcare surrogate. You are letting that decision be known so your healthcare surrogate can then speak with your doctors about that. You're taking that burden off your family. A lot of times we'll see families in the hospital and it gets to this point that they don't know. They don't know if the person wanted to be disconnected or they don't want to be disconnected, and they feel that guilt. You're removing that. You're telling them, these are my instructions. And it's, again, a peace of mind of knowing that your family respected your wishes and what it is exactly that you want to happen in this type of situation. The advantages of the living will: it specifies desired and unwanted treatment for later years, avoids family disputes and eases their burden, as I mentioned, and it lessens the decision-making stress for the caretakers because you're already letting it be known these are your wishes and what you want, and they need to respect and follow those wishes. So those 3 documents, again, those are while you're alive, to make the decisions in case it comes to a situation where you can't make decisions for yourself. Now we're going to go and talk about a little more in depth of a last will and testament and your trusts, the differences, the benefits, and the importance of having these documents in place. So a last will and testament, which I'm sure you've all been familiar with hearing that type of word and have a general idea of what it does, or it's also commonly known as your will or your last will, is a legally prepared and bound document that states your intentions for the distribution of your assets and wealth after your death. I like to say this is your voice on this planet when you are no longer here with us physically. It's you are leaving your written instructions to a judge that says, these are my assets, and this is how I want my assets distributed. So the advantages of having a last will and testament is you control what happens with your property. You also can save your heirs a significant expense and hassle of having to go through other issues, and you will avoid that your assets be distributed according to Florida law versus your decision. So if you pass away without a will, a misconception is that, oh, the state will keep everything. No, the state doesn't want your couch. The state doesn't want your clothes or your jewelry. What happens if you pass away without a will is that the distribution of your assets will go based on the laws of Florida and what we call the laws of intestacy. And I like to describe it as, think of it as kind of going through like a family tree type of situation. Well, first, the court determines, was this person married? Yes or no? If they were not married, did they have children? Or if they were married, also, did they have children? And were the children of the marriage? Depending on those answers, the distribution changes. If we're talking about a blended family situation, the spouse has a certain right in assets, and your children would have certain rights in the assets. If the children are all of the same family, it's one union, then the spouse would have the majority, would inherit all, and then it would pass to your children. But what if you didn't have any children? Then it passes up to your parents, or if not, if they predeceased, then it goes to your siblings and so on. So it goes finding your family members depending on who's alive and who has passed through your family tree. The state will not keep your assets. You might have like second cousin Joe that you haven't spoken to in 5 years. He might inherit your assets, but the state won't. But that's the advantages of having a will. Because if you don't want your second cousin Joe that you haven't spoken to inherit your assets, then you need to have a will saying, these are my desires. These are who I want to inherit my assets. I've had clients that have said, well, first it goes to these family members, but if heaven forbid, none of these family members are around when I die, I want it to go to a certain charity or a certain organization. And you can do that. That's what a will does. It gives you the control of you deciding who you want to inherit your estate and your assets. Now, with a will, it still has to go through a probate process. So that's one of the disadvantages of having a will. A revocable living trust accomplishes similarly what the will does in distributing your asset, but a big benefit that the revocable living trust has is that it avoids your estate having to go through probate. So a trust or a revocable living trust is a written document that allows you to transfer ownership of most of your assets from yourself to your trust and determine how those assets will be handled after you pass away. So the benefits of revocable living trust: your estate is kept out of probate, which is a big thing that we want to do, which allows for your affairs to be settled quickly, privately, and at a less expense. If your estate is taxable, we'll get into what that means. There could be tax advantages by having it placed into a trust. And also it allows the person that you name as your successor trustee to manage those assets, even if you're alive, if you become incapacitated. And definitely once you pass away, then they're in charge of managing and distributing the assets. And also, with having the assets in a trust, it offers protection against court-appointed guardianship should you become disabled. So a trust is a much more robust, much more encompassing estate planning tool that is much better than just having a will. Okay. So the differences between a revocable living trust and a last will and testament: the revocable living trust lets you distribute property privately after death, avoiding probate court. While a will, which is part of a public record, a court proceeding, does not avoid probate, can't manage these rights or responsibilities or debts. So when someone passes away, and if they have a will, that will gets deposited into the court and becomes part of the court record for your estate, and it is public. So if you know any celebrities, any famous people that passed away and they did not have a trust and they only had a will, I guarantee you, you can go online, do a little bit of snooping around, and you can take a look exactly at what their will says, who received what assets they had, because a will is not private. A trust is. So that's another benefit that a revocable living trust gives you. It avoids probate, which a will does not. It is private, which a will is not. Okay. So why a revocable living trust? It can be changed at any time by you as the grantor during your lifetime, as long as you are competent. So can a will, so can your power of attorneys and your healthcare surrogate. So all of these documents, so long as you have the mental capacity, they can be changed at any time from the moment you create them until the day that you pass away. You know, having your estate planning, it's like kind of having like the foundation of your estate plan. That's going to change depending on your situation. I always advise my clients, you should always reevaluate and review your estate planning whenever there's a birth, a death, a marriage, or a divorce. Those four key moments of life are always points in which to kind of reevaluate and take a look at your estate planning. Or if it has been a tremendous, 10 years, 15 years since you did your will. And maybe at the time you did your will, your children were minors and now they're grown adults. Or, you had different assets back then than you do now. But at a minimum, this is when you should reevaluate, because maybe the person that you named as your executor, maybe they passed away. So now you need to change that and name a new person. Or maybe at the time you did that will, you were married, now you're divorced. We got to get that spouse out of there, that ex-spouse out of there, and change your will and the distributions. Okay. So you can always change these, and the same thing with the trust. You can amend the trust and change the trust as needed during your lifetime. So how does the revocable living trust avoid probate? I already mentioned a will doesn't, a trust does. So after your death, your named trustee distributes your estate to the named beneficiaries without having to have the court involved. So probate is avoided because there is no probate property. It all belongs to the trust. So when we create a trust, we set up, let's say, the Nunez family revocable living trust, and we would transfer, let's say you own a home, we're going to transfer by a deed from your individual name to you as a trustee of that trust. And let's say you have a bank account and you want the bank account, it's going to stay in your individual name, but the day you pass away, you want the money that's in that bank account to go to the beneficiaries that you named in your trust. So you're going to go to the bank once the trust is created, and you're going to go to Chase or Wells Fargo, wherever, and say, hey, I've created my estate planning. Here's a copy of my trust. I want to change the beneficiary of my bank account to the trust. And they will change and they will update the record. So the day that you pass away, what does that look like? Let's say you named your sister as your trustee. You pass away, the trust says, when I die, I want the house to go to my niece, and I want the money that's in my bank account to go to my nephew. So your sister, as the trustee of your trust, the successor trustee, is going to go to Wells Fargo or Chase, wherever you bank. Go, hi, bank. My sister has passed away. Here's a copy of her death certificate. The trust was named as the beneficiary on her account. Here's a copy of the trust. I am the successor trustee, as it states in the trust. I'm here to gather the assets that belong to the trust. They're going to check in their system, make sure, yes, the trust is the named beneficiary, and whatever money is left in that bank account, they will close the account, issue a check payable to the trust, and then your trustee will go ahead, deposit that money, and distribute it according to what your trust says. And she would also have the power to sell that house or transfer the deed to, I forgot who it was, niece or nephew, or if they decide to sell it, and the proceeds from that distribute it to the person you named in the trust. So the court doesn't have to get involved. Your trustee is the person who is in charge of handling all of this on behalf of your trust. So comparing wills and trusts. So as we mentioned, a will dictates what happens to your property when you die. During your lifetime, the assets continue to belong to you. Some people think, excuse me, that, well, in my will, I wrote that I was going to leave my son my 1956 Mustang, classic car that I have. So I can't sell it. That's not true. If you want to sell that car during your lifetime and take that money and go travel through Europe, you absolutely 100% can do that. Any assets that you leave named in a will or a trust does not pass to that beneficiary until the day you die. In the meantime, you are the owner. Those assets belong to you, and you can do whatever it is that you want with those assets. Whatever is remaining at the time of your passing is what will be distributed. So then, trust on the opposite side of wills, they also distribute your estate. They can distribute your estate while alive, but also when you die, and the assets belong to the trust. You are the owner of the trust during your lifetime, but they belong to the trust. So that's how they're a little bit different. Where they are kind of meet in the middle or the same is the main goal between these two documents is that it ensures that your property gets distributed how you want. It gives you that control of saying, this is how I want the distribution to be made. It's just they go about it a little bit differently, and the wills and the trust have certain positives and negatives. The will not avoiding probate, not being private, is a little bit of a difference than with a trust that does avoid probate and is private even after you pass away. So a revocable living trust. So the purpose of it during your life is it could also be to help plan for incapacity. Because like I mentioned, while you are alive, you are the trustee of that trust, and you own those assets and manage those assets. So if I transfer my home into my trust and I decide in 5 years I want to sell my home, I can sell it. I'm the trustee of my trust. I sign off on the documents and I can take care of that. Now, sorry, I just saw the comment out of the corner of my eye. Okay, 1964 is the first year of a Mustang. Sorry. No, I am not a car person. So while you are the owner of the trust, you can do whatever you want. Now, let's say, heaven forbid, I become incapacitated. I develop dementia, but I still own this house, but that house needs to be sold. This is like the example I gave earlier. Then my successor trustee can step in and say, I'm now managing the trust. I can sell the property for my benefit because I'm still alive and it's still my money in my trust, but that person can kind of step in and manage the trust if I cannot. So that's how a trust allows you to plan for incapacity, where a will does not. You cannot do that with a will. A will is solely distributing your assets once you pass away. Then, so that's during your lifetime, its purpose. After your life, it's the control of your legacy. How do you want to distribute your assets, and how do you want to make sure who receives what? So with trusts, there are numerous types of trusts, but the most common, and I don't want to overburden you with all this, information, but the most common trust is called a revocable trust. And then there's also an irrevocable trust, okay. So a revocable trust during your lifetime, your revocable trust means that you can make changes to it. You can amend it. You have control over the assets. You can do whatever you want as far as change how the distribution is done. Once you pass away, that trust becomes irrevocable. No one can make changes to it. Your trustee cannot come in and go, well, Alina's not alive anymore. So in her trust, she said that her house was going to go to her son. But you know what? No, I want to leave the house to me. So I'm going to make that change. I'm the trustee, so I can do what I want to do. You cannot. Once a person passes away, the trust becomes irrevocable. No one can make changes to it. And the trustee's job is to distribute the assets in the trust according to your instructions. Okay. Now there's also, again, not to get off track, but there's also during your lifetime, there is a separate irrevocable trust that is used, that's more commonly used for elder planning. If you know that it's someone that's it's going to need in the future Medicaid or any type of planning like that, then there we would use an irrevocable trust during their lifetime, but that's a whole totally separate topic and a webinar for another day. Today we're talking about revocable trust. So the trustee, during your lifetime, you are the trustee of your trust. You manage your assets, you take care of everything. It's all you. If you become incapacitated and you're still alive, then the successor trustee that you named in your trust can step in and manage your affairs. But so long as you have capacity up until the day you pass away, you're the only trustee with control of your trust. Once you pass away, then the successor trustee automatically steps in to distribute the assets. And you can have more than one trustee named, just like I mentioned in the power of attorney and in the healthcare surrogate. You could have two people making decisions, co-trustees or co-agents. Same thing in a trust. You can have co-successor trustees. Again, if you name two people, then you're relying on them. They have to make decisions together and work on the process together. So the assets for a trust, you can transfer in your assets during your lifetime, or you can set it up where if you have the trust as a beneficiary on a bank account, then that asset transfers once you pass. So typically, any real property, we would transfer directly into the trust during your lifetime. So the home you own, we would do a deed and transfer the title to the trust. One thing I want to mention on this, doing that, if it's your homestead here in Florida, if you transfer your homestead property into your trust, it does not affect your homestead exemption so long as it's your trust and you're living in the property. It does not reassess taxes. You can transfer a homestead property into a trust and not have those, those things triggered on there. The other thing with the trust, so if you want to, you can transfer it during life or you can transfer it after life. So that's the example that I gave you earlier where the trust was named as a bank account. The sister went to Chase and said, hey, my sister passed away. The trust is named as a beneficiary on this bank account. I'm here to gather the assets of the trust. That's what it means by that it will transfer after death, where if you have the trust named as a beneficiary. Or if not, if let's say you have a bank account and you thought it had a beneficiary, or maybe you never got around to changing the beneficiary, which is very common, then we always do a will together with your trust. It's what's called a pour over will. It's a little bit different than a normal will. Its purpose is kind of to act as a safety net so that if you do have any assets that you did not transfer into the trust, that will take that asset and put it into the trust. It'll tell a court, I have a trust created. I did a trust. This is what the trust says, and it'll incorporate the important parts of the trust. And it says any asset that I didn't put into the trust, I wanted to pour it into the trust. So that's another way. It's not the ideal way because we want to avoid probate, but if just in case you did leave any asset that was not put into the trust or didn't have the trust as a beneficiary, it will get transferred to the trust by way of your pour over will. And as far as how do you terminate your trust? Well, if it's a revocable trust, during your lifetime, you can terminate it, you can amend it, you can do whatever you want. Let's say you created the trust because at the time your children were minors and your big concern was if anything happened to you, that you had someone managing those assets for your minor children. But let's say we fast forward 30 years later and your children are now grown adults and you say, you know what, I've already given them the assets that they're going to receive in life. I don't need the trust anymore. It served its purpose. We can terminate the trust or we can amend it if it needs to be amended. After your lifetime, how does a trust terminate? Once the assets are distributed and basically it has no more purpose to remain open. So if all the assets are distributed to your beneficiaries, then your trust gets wound down and it gets dissolved, and then your beneficiaries receive those distributions outright to them. If you have a situation where you're leaving assets to a minor, and you wanted to say, or even if they're not a minor, but you can set a condition where you say, you know what, I want to leave some money to my grandchildren, but I don't want them to receive it directly until they're at least 25 years of age, because I don't think they're going to be mature at 18 years of age to know how to handle or invest, let's say, $200,000. So what you can do is we can open up a bank account in the name of the trust, put those funds in there. The trust itself will say that from the monies, $200,000 goes to such grandchild or however people, and on the condition that they have to be at least 25 years or old. If they are not, then it remains in the trust and the trustee will manage it for them until they reach that age. And that way they're going to receive the money, but it's being managed by someone else until they reach that age. And it's there for them. So if they say, hey, trustee, I need some money that grandma left me in my trust because, I'm 18 and I want to go to college and I need to pay for the semester, the trustee can take money from there for their education and pay for that. And then once they reach 25, whatever money's left will get distributed directly to them. So those are all the benefits of having a trust and how the trust works and how you can manage the assets in a trust. So I remember I touched upon a little bit. I said I was going to talk a little bit about revocable versus irrevocable. I just kind of briefly want to touch on these comparisons. Revocable trusts, as I mentioned, flexibility. Terms can be changed during your lifetime. You retain total control over your assets, so you can sell your assets, do whatever you want during your lifetime. Estate tax, it's still taxed on assets above the exemption amount at death. Currently, our exemption amount, so in the state of Florida, there is no inheritance tax. It is not at a state level. That's why people love coming to Florida. We have all our snowbirds coming and buying properties here and transferring their assets here. It is taxed at a federal level, and it is currently at any taxable estate is any value exceeds $13.6 million. Now, this is set to kind of sunset, as we say, in 2026 and go back down to the value that it used to be, which was, I believe, 5.2 or 5.3 million. So roughly like less than half. We will see what happens with that in 2026, given with our administration. If whether or not they will vote on keeping it at the current level or bring it back down. Originally, the amount was increased during Trump's first initial presidency. So considering that he has now won again, I would be inclined to say that it might stay where it's at, but we'll see. But at least until 2026, we know it's on anything above the 13.6 million. So anything above that is considered a taxable estate. Anything below that, you're good. Don't have to pay tax on that inheritance. Okay. But if it is more, we have other trusts and other ways that we can avoid having to pay taxes, or at least try to minimize. And in a revocable trust, it's not always protected from lawsuits and creditors. The reason why, because you're retaining control and ownership. So that's a very common question I get. They're like, oh, I want to protect myself from creditors. I want to protect myself from creditors. Well, depending on your assets, there's probably other better ways to do it than not just doing it solely with a revocable trust. A trust is more for estate planning, tax planning. Irrevocable trusts, the terms are locked in at the creation of the trust, and it cannot be changed. You have no control and no ability to change the terms of your trust. And you give up total control of your assets. That is why it does give you certain protections that a revocable trust does not for creditors. But you're trading one thing for another. You want protection from creditors, then you have to give up control of your asset. That's how you protect. So it doesn't all just, it's not just, it's pick your poison type of thing. There's no tax on assets since the assets are outside of your control, and it does give you certain protections. But you have to be very careful. When I sit down with clients who come to me for irrevocable trust, I go very in detail with them as what's their goal, why are they asking for an irrevocable trust, and do they know what exactly that means, and the consequences of having an irrevocable trust. Because once you go down that route, you cannot change that. One example I want to give, some of you might be familiar with this. If not, it's already been 30 years since this happened, or 30 plus years since this happened. But this has always been a prime example of what I give as to why it is important to do your estate planning. We all think that we're going to be on this earth for many, many, many years. But unfortunately, we have no control over that. And Terry Schiavo, it was a case here in Florida back in 1990. She was 26 years old. She had a heart attack, but she did not die. She was left brain dead, and she was in St. Petersburg, Florida. She was resuscitated, but because of the amount of time she was without oxygen due to the heart attack, she was left as a vegetable. After 2.5 months of seeing no improvements whatsoever, and the doctors were basically called that she was going to be in a persistent vegetative state. A legal battle ensued because she did not have her estate planning documents in order. It was 15 years of legal battles between her husband and her parents as to who had the right to make the decision to disconnect her from the life support. Her parents fought her husband on it, and this was 14 appeals. It went not only to the Florida Supreme Court, it went to the U.S. Supreme Court, who finally ruled that her husband had the right to make the decision, and he removed her from life support. Once he did, obviously she passed away because there was no probability whatsoever of her being able to live. But these two families endured 15 years of legal battle, 15 years of seeing this person lying in the bed as a vegetable, and the money and stress that this caused simply because she did not have anything in writing. Where if she would have left her living will and her desire to saying, this is what I want, it would have resolved that. So this, to me, is a prime case and an example of the importance of making sure you have your estate planning done, because you do not know what life will throw your way. And she was just 26 years old. So I'm going to take the last 10 minutes to answer any questions that you guys have. I'm going to go through the chat, and I see here, is this presentation will be shared or provided? Yes, we can. We're going to be also uploading it into our YouTube channel, so you can always please check it out there, Nunez Law Florida, and we have a bunch of other videos that we do. I also want to give you guys an incentive, a thank you for being on here. So for those of you today that attended this webinar, if you have not done your estate planning with us and you have not had a consultation with us, if you schedule a consultation with us through the end of the year and you come in and meet with me before the end of this year, I will waive my $200 consultation fee as a thank you for attending and taking that initiative of getting your consultation appointment made. Just let my person know that you attended the webinar, and they are going to be aware that we are going to be waiving this initial consultation to get you in here and sit down with me for an hour and go through your questions and your specific estate planning. Because this was a general overview. Everybody's situation is different. If you have minor children, there's other things you need to take into consideration. If you come from a blended family where you have stepchildren and a second spouse and whatnot, there's different things that can take into a consideration. If you have a same-sex relationship, there's different things that need to be taken into consideration. So not every estate plan is a plug and play for each individual. So it will be shared and provided. Does a durable power of attorney need to be one person, or can be more? It can be more. Like as I mentioned, if you are going to name more than one person to serve together, then those two people would have to make those decisions together. If not, typically it's, you name a primary, you can name a second, you can name a third, a fourth, a fifth, a sixth. I think the most I've ever had was a client had, I think it was 6 children, and she didn't want to leave any of them out. So she named them all in order of her preference of who to make those decisions. But hey, they were all on there, and she had peace of mind that they would, each have a turn and making a decision if need be. Revocable living trust versus TOD, transfer on death, and beneficiaries on bank accounts, investments, and IRAs. Anything with a beneficiary. So whether it's a beneficiary, transfer on death, which is TOD, or a POD, pay on death, that is having a beneficiary named. That will go directly to the person that you have named. So if you create, and it will not go through the trust, and it will not go through probate. So for example, my very simple estate planning, and I know everybody thinks that theirs is simple, but truly a very kind of simple, where they might have one bank account and they might have one property. As long as they have a beneficiary named on that bank account, and we could get something done with the property, they'll be fine. Anything that has a beneficiary will not need to go through probate. So if you want to change it, you do want those assets to go through the trust, you need to change that POD, you need to change that beneficiary to the trust. Audio is going on. Oh, I apologize that the audio was having some issues. When I get into this, okay, okay. No, I'm not a car person, JD. Social media keeps recommending a trust over a ladybird deed. Yes, absolutely. The explanation is so that the heir is not subject to high taxes. No, that's not correct. Can you explain why taxes, what taxes they were talking about, estate tax, gift tax, property tax, and how does that work in Florida? So a ladybird deed is a very simple estate planning tool that we use, and it's only for real property. It's the equivalent of basically naming a beneficiary on that piece of property. So going back to my, what I was saying of my simple estates, I like to call these my abuelita estate planning, where they have a piece of property and a bank account. And they know that when they die, they want that piece of property to go to that adult child. We can do that with a ladybird deed. A ladybird deed gives you the ability to remain in control of your property, sell it, mortgage it, rent it, live it, do whatever you want with that property. Upon your passing, then it passes to the person that you name in that document. Now, what are the limitations? And I've done webinars on ladybird deeds, and if you guys are interested, I can be happy to make my next webinar probably for the month of January on ladybird deeds. I know that we hear that a lot online, and it's a good tool to use. But what are the limitations? The limitation is you cannot name a minor as the remainder on that ladybird deed. The limitation is, what if the person you named passes away before you do? You have to change that ladybird deed. You can't say, I leave my house to my sister, but if my sister were to pass away, then I want it to go to my brother. You can't do that with a ladybird deed. You absolutely can do that with a trust. So there are certain limitations. As far as the taxes, the benefits of both a ladybird deed and a trust is that you take advantage of what we call the step up basis. So if you, let's say you own a property and you bought it in 1990, and the day that, and when you bought it, it was worth, let's say 150,000. And the day you pass away, with the way house prices are in Miami, that house is now worth $1 million. That equity that you have built up in that house is a gift. It's not taxable to your heirs. That's called the step up basis. Now, when they inherit it at $1 million, depending on whether they keep it or they decide to sell the house, anything that they gain from that moment to the time that they are done with the property, or they sell it or whatnot, that is taxable. That is capital gains taxes. Okay. Property taxes, those are going to go up regardless if it's in a trust, in a ladybird deed, or what. When a person passes away and real property passes to their heirs, the taxes get reassessed. Property taxes will get reassessed, and the person who had the homestead exemption will lose, obviously, their homestead because they have passed away. So that part of the taxes, that is unavoidable. Possibly what it was talking about was maybe capital gains taxes or that step up basis. Those are ways that a trust and even a ladybird deed can be helpful for estate planning. So can a revocable trust be made if the person already has Alzheimer's and is cognitively impaired but is still functional? No. If they do not have the mental capacity to sign a legal document, they cannot. And this is the number one issue I have, where people came to me, met with me. Oh, I know I need to do this. I know I need to do this. And they never got around to doing it. And now mom or dad has dementia and it's scrambled because we need to get a power of attorney done, or we need to get our affairs in order. If that person has been already diagnosed and they have signs of dementia, it is too late. If I have any doubts as to the person's mental capacity when I sit down and meet with them, I will require a doctor's letter to confirm and tell me whether or not this person has legal capacity, mental capacity. Also, I have had clients where I've had them sign documents at the hospital because they went in or they're about to go in for a procedure or whatnot. Same thing. I request a letter from their treating physician at the hospital to protect myself and protect their heirs, to state that they have the mental capacity to sign this document. But if you've waited too long and the person already has dementia, they cannot sign any sort of power of attorney or any estate planning documents. Is there an advantage to setting up both a revocable trust and irrevocable trust setup? On fund, the irrevocable trust, if something catastrophic happens and you need to transfer assets quickly to protect yourself. Well, that's a two-part kind of question, and the answers to that is, I'm going to give you your typical attorney answer. It depends. Transferring assets quickly that can be looked upon by a court, depending on the reason why. If you're trying to transfer assets to avoid a creditor, even though you transfer them into a trust or an irrevocable trust, trying to protect yourself, and if you know that you have a pending creditor or a pending lawsuit, a court can look back into that, and they can go back in time and see that transfer and determine that it was a transfer made purposely to evade a creditor and basically undo that transfer. Same thing with Medicaid. Medicaid has a 5-year look back period. If you have assets in your name and you're trying to transfer the family member's name, you're trying to transfer it last minute because they need to qualify for Medicaid, they have a 5 years that they can go back and see any transfers that were done. And if they believe it was done with the purpose to avoid or evade Medicaid, having to pay back Medicaid or to qualify, they could deem it that it was invalid transfer. So the answer to that, it depends. Will adding a property into a trust, thereby modifying ownership as the trust now owns the property, change the current taxes on said property? No. As long as it is your homestead and you are only transferring from your name into your own trust, it will not affect the property taxes. It will not affect your homestead exemption. There's actual language built into the trust that states that you have a right to retain those rights to homestead and reside in the property. Now, if you're going to add someone else to the title, then yes, there it could trigger a reassessment. We're in time for recording. Thank you. Have a meeting next week. Glad to hear. Wonderful. Hope to see you next week, Teresita. Yes, consultations. We do consultations by Zoom. Absolutely. I had one this morning for estate planning. We can definitely. My question, how much does state law matter? Do you need to prepare your will or trust in the state of your primary residence? I ask because my assets are split between the 2 states, but Florida is my home. You should prepare your estate planning in the state where you reside and you are domiciled. So the consultation I had this morning, actually, he resides partly in New York, partly in Florida, but his main domicile is here in Florida. He does spend some time, but he resides here. His assets are here, so they would be prepared here in Florida. I've had clients that reach out to me and say, no, I'm planning to move. I'm like, if you're planning to move permanently in 6 months, my suggestion is do your estate planning in 6 months in the state where you're going to be permanently residing in. Does a trust avoid the executor from filing a final tax return? No, you still need to file tax returns on behalf of a trust. The service fee for a revocable trust is, I'm assuming you're asking what we charge. Those, as I mentioned, it's very unique to each person. Our basic trust packages, which includes the trust, wills, power of attorney, healthcare surrogate, living will, and the deed to transfer your property into a trust, start at about $4,000. And then depending on if we need to add any other type of, if you have minor children, guardianship documents, anything like that, it could be a little bit more. Or if you have multiple properties, or if you have businesses or corporations. So that's why it really is unique to each person. But to give you an idea, I know that's somebody's always biggest concern. Roughly, I would expect to start to spend anywhere at a minimum of $4,000 on a trust. Just to put into perspective, I know some of them, oh my God, that's a lot of money. An average probate case can run anywhere between $8,000 to $10,000, if not more. And that's with nobody fighting. So just want to put it in perspective there. But power of attorney, Lady Bird deed webinar will be great. Wonderful. We'll get that. Thank you. If all your assets go into a trust, how do legit creditors collect? Do the creditors sue the trust? They can file a claim against the trust. They can file a claim if they feel like there is assets that can be distributed to them, even if they're in a trust, and we would have to deal with that once you pass away. The good thing is, again, in Florida, one of the many protections we have with our homestead is our homestead property is protected from any creditor claims. So your homestead property is 100% protected. They cannot force you to sell it. They cannot go after it. And that homestead protection passes down to your lineal descendants. So your children, your spouse, they take advantage of that homestead protection once you pass away. So awesome. I think that is all the questions. Again, thank you guys all for attending. I appreciate we ran over a little bit. I want to be respectful of everyone's time. Remember, if you attended today, you want to schedule a consultation through the end of the month, through the end of the year, let my team know that you attended today's consultation, and we will webinar, and we will waive that $200 consultation fee as a thank you for supporting and joining us. And check out our YouTube channel. As I mentioned, follow us on social media. I'm constantly putting out videos and information. This Friday. We're going to be shooting a bunch of more new videos and constantly keeping the content fresh. And any questions you guys want me to address, put it on social media, comment in our posts. Let me know what you want to hear about. I'm here to try to help answer the questions that you want to hear. All right. Have a wonderful day, and thank you for joining us. And until the next time, thank you very much.